Good morning or good afternoon to wherever you're joining us from, and thank you for attending today's webinar and our final webinar of 2021. My name is Daniel Johnson, and I am the Director of Marketing and Customer Experience here at myHRcounsel. And I just want to thank you for attending today and your continued interest in our monthly webinar series if you've attended one of our webinars before. Just before we get started, a few housekeeping before here. As always, we will record our webinar, so if you have to jump off, we will have that recording for you as well. We will be sending up a follow-up email that's going to have that recording, the slide deck, as well as the HRCI credit if you need recertification credits. We'll also have a survey. We really encourage you to fill out this survey as it provides us with great feedback for our upcoming webinars. And now I'll pass it off to our presenter today, who is Britt Waterman. She is a senior attorney here at myHRcounsel. Thank you, Britt.
Great, thanks, Daniel. So today we're going to be talking about preparing your company for the first 90 days of 2022. There are a number of things that companies are always very interested in talking about or preparing for in the first quarter of the coming year. And so I'd like to discuss some of those things. So today we'll be talking about the employee retention tax credit, which is something that is new to specific to the pandemic and the related laws. We're going to talk about ACA reporting, which I know is everybody's favorite topic. I'm going to talk about employee handbooks because the first quarter of the year is always the time that you should be thinking about revising your employee handbook. And we'll get to some specific state law updates as well. I do also have an update on the OSHA ETS, also known as the vaccine mandate. So I will update you on where that is at currently. So let's get to the employee retention tax credit. Time is running out on this, and I just want to give a quick disclaimer that our webinar today is for informational purposes only. I'm not providing you with actual legal or tax advice. So we'll provide information at the end of the presentation on how to access our services. As always, if you're one of our clients, please open up a ticket. We'll be able to provide you with legal advice. That way, if you are not one of our clients, Daniel will talk about our packages, how to become a client of myHRcounsel, and then, of course, you would be a client. We would be able to offer you legal advice that way. Just viewing the webinar, however, I cannot provide tax advice solely through the webinar. So please, if you are a client and you see something and it raises an issue in your brain, please open a ticket. And like I said, if you have questions and you are not a client, we'll definitely give you information as to how to get started. So just a brief disclaimer about the webinar itself and its purposes. So the Employee Retention Tax Credit, the Infrastructure Investment and Jobs Act has accelerated the credit retroactively to October 1st, 2021 until rather than January 2022. The Employee Retention Tax Credit first came into being under the CARES Act in 2020 in the early stages of the pandemic. It was later updated by the American Rescue Plan Act in 2021. The purpose of the ERTC is to encourage businesses to keep employees on their payroll and to keep paying them rather than letting them go during the pandemic. The function of the ERTC was to provide fully refundable tax credits for employers' qualified wages. That includes qualified health plan expenses, and that was wages and health plan expenses that eligible employers paid their employees. The availability of the ERTC, the tax credit was available for any employer whose business operations were fully or partially suspended due to orders from a governmental authority. So that was any where public health authority or executive order from the state government or federal government ordered you to lock down to cease business operations, or an employer with a significant decline in gross receipts. So the amount of the ERTC up to $7,000 per employee per quarter. Previously was up to $5,000 per employee per quarter. It has been increased to $7,000. This means that the Infrastructure Investment and Jobs Act, which was signed into law in November, does retroactively eliminate the employer's ability to claim that credit for wages in the fourth quarter of 2021 and changes the maximum ERTC amount per employee available in the tax year 2021 to $21,000, not $28,000 per employee. That's still hardly an insignificant amount. So the credit can be claimed going back 3 years by filing an amended payroll tax return. So the program's going to sunset, but you can still claim the tax credit by filing Form 941X. So Form 941 is the payroll tax return that you file every quarter. Form 941X is the amended return that you go back to amend the 941 that you've already filed, and the current statute of limitations to amend your return or to file the original or to amend the return is 3 years from the date that the original 941 was filed. So for 2021, like I said, an employer can receive 70% for the first $10,000 of qualified wages, and that includes health plan expenses per employee in each qualifying quarter. That applies to wages paid or incurred from March 13th, 2020 through September 30th of 2021. Again, that is up to $7,000 per employee. Eligible employers, you've private sector businesses and tax exempt organizations. If you experienced a full or partial shutdown of operations, like I said, an order limiting commerce due to COVID-19, a gross receipts decline of more than 50% for 2020 versus 2019, or a gross receipts decline of more than 20% with regard to 2021 versus 2019. Next steps with the ERTC. Employers may be able to receive payments through these ERTC refunds. myHRcounsel and our team have been assisting our clients in filing for their ERTC refunds. If you retain our team for that service, there is no upfront fee or no hourly billing like you would get with a law firm. Instead, our payment arrangement would be 15% of any amount recovered from the IRS for the ERTC. That would be a contingent fee arrangement that we would offer, meaning you would only pay us if you received an ERTC refund payment or payments from the IRS. So currently that is what we are offering to assist companies with filing amended 941 returns to get refunds on payroll taxes to get that credit of up to $7,000 per employee. So please contact us with for assistance in filing for that tax credit. The 15% contingent fee is very low. That's going to save you a lot as far as going to as opposed to going to a traditional law firm or going some other route. And again, this is only if you receive refunds from the IRS that you would be paying us that fee. ACA reporting, everybody's, like I said, everybody's favorite topic. We're talking about Q1 of 2022. Do not leave all of your updating for Q1 of 2022, although it is obviously getting very close. So for those of you who don't have a lot of familiarity, the Affordable Care Act was passed in 2010. It requires employers to provide compliant group health coverage to employees or face steep penalties if these eligible employers do not provide compliant group health coverage. And so after 6 years of required reporting at this time, many employers are now familiar with the requirements of the ACA. But some employers may have grown, recently added employees, and only recently become covered under the ACA. If an employer has at least 50 full-time employees, including full-time equivalent employees on average during the prior year, the employer is considered an applicable large employer for the current calendar year and is therefore subject to the both employer shared responsibility provisions and the employer information reporting provisions. So if your head count's increased, this could be a new issue for you. You could be coming into uncharted territory. If it's not a new thing, you're probably familiar with the time crunch and trying to cram this all in with W-2 reporting and other beginning of the year requirements can be tough. So the best practice, and even though we're talking about preparing for Q1, like I said, the best practice is to use ACA tracking software product throughout the year. I'm sorry, I'm just recommending this now, but that would be the best practice. And to get on track for 2022 reporting, something you should be looking into in the first part of 2022 is how to get on track with some ACA reporting software and implementing that to make the following year go much more smoothly for you. So you need to report employee names, hire dates, termination dates, offers of coverage, whether or not they were declined, what the cost of coverage was. You need to report each employee for each month of the year. Most covered employers know about forms 1094C and 1095C. Some employers who are self-insured may also have to complete 1094B and 1095B. So make sure that you know what forms are applicable to your company. Again, if you have questions, if you don't know which forms you need to file out, that is something that we can help guide you through. Again, open a ticket or definitely reach out to us and ask any questions you have about what type of assistance we can provide. Another issue has to do with an aggregated ALE, and that refers to a group of affiliated entities, and there's a different process of linking the 1094C and 1095C forms when there is companies with common control. That's going to throw another wrench into the reporting process that you will need to prepare for. But preparing now for ACA reporting, grandfathered plans. What is a grandfathered plan or grandfathered status under the ACA? So grandfathered plans are health plans that were in place before March 23rd, 2010, when the ACA was signed into law. So these plans are still allowed to offer the coverage they did before the ACA. So right now you should be evaluating the grandfathered status of your group health plan. If you have a grandfathered plan, you need to determine whether there are any changes that threaten the grandfathered status. If you have made a change that does threaten the grandfathered status, you need to determine whether the change does change your status or confirm that your new plans meet the ACA requirements. If a change does not change the grandfathered status of your group health plan, you do have to provide a notice of grandfathered status to your participants and beneficiaries whenever a summary of plan benefits is provided. An important annual step is to look at your plan documents. So some of the steps here: make sure your waiting periods do not exceed 90 days. Confirm that your no annual dollar limits apply to coverage of essential health benefits. No pre-existing exclusions. That's one that's I think very familiar to most people. You should not have an employer payment plan in place. Now, an employer payment plan is an arrangement where an employer reimburses an employee for some or all of the premium expenses incurred for an individual health insurance policy as opposed to a group health policy, or the employer uses its funds to directly pay for the premium for an individual policy. So these are considered plans that do not comply with the ACA, which requires you to offer group health coverage. There are exceptions, certain types of HRAs. We'll get to that here in just a minute. Right now you should be analyzing any of your tax-favored arrangements, your HRAs, your health FSAs, your cafeteria plans, making sure these are compliant. A health reimbursement arrangement, an HRA, it's an employer-funded plan. It reimburses employees for qualified medical expenses, in some cases insurance premiums, and employers are allowed to claim a tax deduction for the reimbursements they make through these plans, and the reimbursement dollars received by the employees are generally tax-free. So in 2020, a new type of HRA became available relating to the ACA, and that is the Individual Coverage Health Reimbursement Arrangement, or the ICHRA. So employers of all sizes that do not offer a group coverage plan can instead fund an ICHRA, and employees can use the employer-funded ICHRA to buy individual market insurance, including insurance purchased on the public exchanges formed under the Affordable Care Act. So those are the marketplace, or the public exchange would be when you go to healthcare.gov, and it shows you where to go to buy insurance in the marketplace. So employees can use an ICHRA to buy individual coverage insurance on the marketplace. This is a very complex area, and you want to review and make sure that the plan requirements are satisfied. So this is, again, something that you're going to need counsel to walk you through. If individual coverage HRA and ICHRA, or qualified small employer HRA, QSERA, is offered, you need to provide employees with applicable written notice at least 90 days before the beginning of the plan year. So depending on when your plan year begins, this is something that you should be thinking about now to prepare yourself for the beginning of your plan year. FSAs, flexible spending arrangements. This is a type of savings account that provides the employee with specific tax advantages and allows employees to contribute a part of their regular earnings. Employers can also contribute to the accounts. How FSAs relate to the ACA. So the ACA requires healthcare FSAs to be considered an accepted benefit to avoid being subject to the ACA market reform provisions, the preventative services requirements. So 2 FSA accepted benefit requirements. So 1, employees eligible for the health FSA must also be eligible for the employer's group major medical plan. And 2, if the employer contributes to the health FSA, the maximum contribution provided by the employer cannot exceed $500 unless the employer is matching the employee's contribution dollar for dollar. Other compliance steps: confirm that your health FSA is offered through a cafeteria plan. Again, certain requirements here to allow employees to receive benefits on a pre-tax basis. Make sure your plan documents are amended to reflect employee salary reduction. Contributions are limited to a certain amount. For 2021, the contribution limit is $2,750. Again, this is something, a simple legal question that you could open up a ticket and receive an answer to in 2 hours time or less. If you are a client, you should determine whether you will allow employees to carry over up to $500 of unused health FSA amounts to use in the following plan year. Again, cafeteria plans, we touched on, it's an employee benefit plan that allows your staff to choose from a variety of pre-tax benefits. And if you offer a number of pre-tax benefits, you're probably familiar with the cafeteria plan. Compliance steps with your cafeteria plan. Right now, you need to determine whether you're going to allow employees to make additional mid-year changes in their salary reduction elections in the event of an employee's enrollment in health insurance marketplace coverage and or a reduction in an employee's hours of service. Very important, as we saw with the pandemic, many employees having their hours cut. So that's a decision you have to make, a determination that's important. And then also confirm that your cafeteria plan, your Section 125 plan documents comply with the prohibition on providing a qualified health plan offered through the individual health insurance marketplace as a benefit under the cafeteria plan. So you need to provide required notices. You need to provide a written notice with information about the health insurance marketplace to each new employee within 14 days of his or her start date. You do not need to provide that notice separately to dependents. You need to confirm your contractual arrangements with your carrier, your insured group health plans, or your third-party administrator for self-insured plans to prepare and provide your summary of benefits and coverage. If your carrier or your third-party administrator does not assume responsibility for this, you need to provide this notice without charge to your employees and beneficiaries at specified times during the enrollment process and upon request. So you should, one thing to be preparing for the coming year, checking with your insurance carrier or your TPA to determine who is going to be responsible for delivering the summary of benefits and coverage to your employees at the appropriate times. And there are compliance regulations if you do enter into a contract with another party to provide this summary of benefits and coverage. Another area where legal counsel is very helpful. You do have to ensure, of course, that your enrollees are provided with notice of any material modification that affects the content of the summary of benefits and coverage. So as we previously discussed, applicable large employers, employers with 50 or more full-time or full-time equivalents, are subject to the ACA employer shared responsibility requirements, the pay or play requirements. Again, this is very complex. Due to the complexity of the law in this area, we strongly encourage employers to work with knowledgeable employment law counsel to ensure full compliance. This is an area that is very difficult for an HR department, for a small to medium-sized employer to have if they're doing in-house payroll, to have them attempt to wade through this on their own. We just don't recommend it. We recommend that you have employment law counsel to ensure that you are compliant. So you need to determine your ALE status for the upcoming calendar year by calculating the numbers of employees across the months in the current year. You need to determine whether your group health plan coverage will be offered to full-time and full-time equivalent employees and their dependents using the measurement methods. for calculating, and the rules for calculating the hours of service. So this is something, again, where we recommend using software and consulting with counsel. You have to review your group health plan coverage to determine whether it is affordable. Under the ACA in general, coverage in 2021 is affordable if an employee's required contribution for self-only coverage does not exceed 9.83% of their household income for the taxable year. And again, that's something that the IRS changes that number every year. So you want to make sure that your plan is affordable and that you are looking at the correct amount. Determine if a penalty may apply if your plan does not offer minimum value to your employees. You're going to need to review and respond to the dreaded IRS letter 226J if applicable. This is a letter that the IRS issues if it determines that for at least 1 month or in the year, one or more of the ALE's full-time employees was enrolled in a qualified health plan for which a premium tax credit is allowed, and the ALE did not qualify for a safe harbor or other relief for the employee. So when you get the letter 226J, you do have to complete the response form indicating your agreement or disagreement and follow the appropriate instructions. Again, this is something we have helped many companies with the 226J letter, and that's something we can help our clients respond to. So again, clients open up a ticket, we get an attorney on the case to respond to that letter. That's something that would be based on your plan that would be included in your package. So the bottom line is that the ACA is a complex law. Compliance involves many factors. Don't wait until the end of the year to work on the beginning of the new year. Do this throughout the year and start thinking about this for 2022, setting up your plan. How are we going to spread out our ACA reporting responsibilities over the coming year so that we are not in a terrible time crunch at the beginning of 2023, and consult with counsel. I would always recommend consulting with counsel when it comes to the ACA. Employee handbook reviews, this is so important at the first of the year. This is when you need to be looking at your handbook and reviewing your handbook, updating your handbook. State and local laws are changing all the time. A lot of laws become effective on the first of the year. Outdated handbooks can be a compliance disaster for you. I've got the top 10 most common employee handbook errors. Mistake number 1, you pulled an employee handbook off of Google or some public university puts their handbook on the internet with an employee handbook on Google. You don't know who's had their hands on that handbook and who it's passed through before it's been in the form you found it in. There could be any number of illegal changes and alterations made to that document. Public universities do put their handbooks on the internet. They look great, they look incredibly professional. However, they do not necessarily cover the cities or the states you have employees working in or your specific industry. And also public employees laws are defined by statute. There are countless things that would apply to a state employer like a public university that are going to be very different for you as a private employer as a matter of law. So there are many things that are not going to be applicable to you and things that are applicable to you that may not be in that handbook. So pulling that off the internet is a big mistake. Mistake number 2, missing protected classes. So your EEO statement and your anti-discrimination harassment policy should list out all of the protected classes for your jurisdiction. Now you may think, well, we've got race, sex, national origin, religion, I think we're covered. You know, you have to look at your state or local protected classes. Michigan includes height and weight. Minnesota includes recipient of public assistance status. New York includes political activity. You have to indicate that you cannot discriminate on the basis of political activity. These are ones that without employment counsel, you would absolutely miss and leave out of your EEO statement. After the Bostock decision, which is a Supreme Court decision that was handed down in the past year, you must include sexual orientation, gender expression, and gender identity, including status as a transgender individual in your list of protected classes. This is not an issue of agreement or disagreement or preference or how you feel. This is a matter of law, and it does need to be included. Some jurisdictions have added natural hairstyle to protected classes over the years, and some are adding it as of January 1st, 2022. So you should definitely consider adding that or checking to see if that's a protected class in your jurisdiction. Mistake number 3, this is an employee manual. It is for communicating the law and the rules to employees. This is not for HR talking to HR. Have an HR manual if you need it, but this is an employee document. It is also a legal document. This is not where you tell employees how to answer the phone and where to park. That should be a separate training or operation manual. It is fine to have that. You should also have counsel review those if you are handing those out, because I have definitely seen training or operations manuals that contain all kinds of illegal bits and pieces that employers are communicating to their employees that could be setting them up for a lawsuit. So, but the employee handbook is a legal document. And it also needs to be drafted by an attorney and contain very specific things. So this is something that is a legal document. It should be limited to a very certain number of items, and it should be drafted by an attorney. Mistake number 4, forgetting that the National Labor Relations Act applies to your company too. Even if you don't have unions, you need to remove provisions like confidentiality of wages, benefits, or working conditions. You have a rule that says employees can't talk about their wages with other employees. The National Labor Relations Act prohibits that, and you are out of compliance. If you have that in your handbook, you need to take that out. Rules against disparagement of the employer. You could be treading on thin ice with this too. There's really, you're really splitting hairs on that one. It needs to be worded extremely carefully, and you need an attorney to navigate around all of the decisions and guidance that have been handed down by the NLRA to make sure that you are crafting that in a way that protects you legally. Rules against making false or inaccurate statements, any kind of rules of making statements about the employer. Social media is a big issue. You want to make sure you're not running afoul of the NLRA, even if you have the best of intentions about protecting your company with regard to social media or public statements. You need an attorney to keep track of all the guidance that's been handed down. Now, National Labor Relations Board members are appointed by the president. So something that a board with a majority of members appointed by a Republican president could be overturned when members appointed by a Democratic president start to fill those slots. You've got HR to deal with, you've got your employees, you've got payroll, you've got protected leave, you've got all kinds of compliance to deal with. You don't have time to monitor the National Labor Relations Board's website and check every day for new decisions and new guidance. That's why you need an attorney. That's what we're trained to do. That's what we're here for. If you don't have an attorney monitoring that guidance and updating your handbook and reflecting that in your handbook, you could end up violating the NLRA without even knowing it. Now, there is a Democratic majority expected in the NLRB in the near future because President Biden has appointed members to the National Labor Relations Board. So look forward to things changing. They're not static. So look forward to changes being made, and that's something that you need an attorney to stay on top of for you. Mistake number 5, forgetting to add an at-will employee disclaimer. Don't create a contract and find out that you have not included an at-will disclaimer, that your handbook has bound you to the employee. Suddenly you want to terminate someone for performance. and you realize you have to give them 30 days notice or pay them in lieu of notice, or some other obstacle to termination that comes up because you did not make it clear that employment was at will, that's going to be a problem. And so that's something that we can help you word. You want to be very careful about that and include that at will employee disclaimer. Mistake number 6, thinking that your short and sweet anti-harassment policy is good enough. Brush off your policy and make sure it includes specific definitions of what harassment is, what to do if it happens, what your reporting procedures are. Right now, 11 states have statutory requirements for what needs to be in that policy, down to the smallest detail. They include rules for managers and supervisors. So it's not just one policy fits all. They've got a portion of your policy that applies to employees. You need to have a separate provision for managers and supervisors. There's anti-retaliation provisions that need to be in there. There's directions on how to make an internal complaint, how to report to a manager, a supervisor, HR, the president of the company, how to bring it up the chain. They need to have directions on how to make an external complaint. You may need to put in your handbook the address and phone number and website of your state human rights department, and how to get in touch with them and how to file a complaint. And this is something that some employers balk at and say, no, we do not want to send our employees running in the direction of the State Department of Human Rights. In some states, you need to do exactly that, or you are setting yourself up to lose a sexual harassment suit. If you're in one of these states and your handbook policy does not contain all of these specific statutory requirements, you are in violation of state law, and you basically just handed a claimant one more piece of evidence to use against you. So make sure that your anti-harassment policy is compliant with the law in your jurisdiction. And even if you do not have a state law spelling out what needs to be in it, make sure that it is something that is going to protect you in the case of a discrimination or harassment lawsuit. Make sure it is very clear, very specific, very detailed, and very protective of your employees. You want this. This is something that could be blown up on a screen in front of a jury someday. You want to make sure that it looks as though you do not tolerate harassment, and you've made that very clear to your employees. Another example that I like to bring up, Tennessee has a model anti-harassment policy that they put out that is completely optional for employers to include in their handbooks. But if employers do include this Tennessee model anti-harassment policy, it can protect the employer against some liability in a harassment suit. If you don't have an attorney drafting your handbook, you have no idea that these laws are out there. Like I said, you're busy, you've got enough on your plate, you don't have time to engage in a fishing expedition for laws when you don't even know that you're looking for. You need to rely on an attorney to know what the laws are in your state. If you're in Tennessee and you've never heard of this particular law, you're missing out on a great benefit that an attorney could have provided for you and put into your handbook had you had an attorney draft your handbook and had you updated that every year. Mistake number 7, so having a progressive discipline policy that is too rigid, you need to be able to skip steps based on the offense. You cannot say in every case it is verbal warning, written warning, performance improvement plan, termination. Every offense is going to be different. You know, there are going to be all kinds of offenses, and you need to be able to consider the facts and the circumstances of employee conduct. Each incident kind of on their own and you do not want to be locked into a progressive discipline policy that ties your hands. And when an employee embezzles hundreds of thousands of dollars from your company, you are stuck giving them a written warning. There are cases that where employers have had progressive discipline policies that have been too rigid. They have required reinstatement or back pay of employees who have done terrible things. Employees that no employer would ever want to retain, and because the progressive discipline policy in the handbook was too rigid and did not allow the employer to skip steps, the employer was forced to reinstate this employee or pay back pay to the employee as a result of their policy. So you really want an attorney looking at that policy, and you want to, to do that every year just to review, make sure that that is something that's legally compliant. Mistake number 8, not getting your employees to sign off on your handbook. When somebody sues you for wrongful termination and you want to counter and say, well, no, he was terminated for violating X policy. How is it going to look for you when you can't even prove that he ever heard of X policy? This is why you need a signed handbook acknowledgement. You need the employee to show, and you need to phrase it so that the employee, by signing, is agreeing that he or she has read the employee handbook, that they agree to be bound by the contents of the employee handbook, they agree to abide by the contents of the employee handbook as a condition of employment, and that you can amend or modify the contents of the employee handbook in your sole discretion. And again, that's where an at-will disclaimer is going to come in, but you want to have the employee signing something that is very clear that they are affirming, yes, I am responsible for the contents of the handbook, and I cannot come back later and say I didn't read it. If I didn't read it, that's on me. That's what I'm agreeing to. If you don't have a signed handbook acknowledgement, that shows that the employee knew exactly what the rules, rights, and responsibilities are, and you've got an employee who is terminated and claims that it was discriminatory and that there was no policy and he had never heard of a policy. If you don't have a signed acknowledgement, you may as well be handing evidence to the other side on that. So, and these acknowledgements, like I said, I just shared some language, they need to be worded very carefully. Like I said, you don't want to create a contract, but you do want to place the responsibility for abiding by the policies, understanding the policies. You do want to shift that onto the employee. So that's something that legal counsel can word for you in a way that is compliant, that is not going to trap you into a contract, but that is going to protect you in the case of an employee claiming that they were terminated wrongfully, but they had no idea what the policy is. So that's something where having legal counsel is very helpful in drafting your handbook. So mistake number 9, forgetting that some types of leave policies such as FMLA are required to be in the employee handbook. This is something that I see a lot where companies say, well, I heard FMLA only applies to employers with 50 or more employees, and we have 47, so I'm not going to include it. If you are close to 50, put it in there. You don't want to hire 3 people mid-year and then have an out-of-compliance handbook. Also, FMLA is not the only leave law in the game. Most states, or many states, have FMLA type laws that are state specific as well. Some of them apply to employers with 1 or more employees. Some of them apply to with 20 or more employees. Some of them are parental leave policies. Some of them are family care policies. There are all kinds of leave policies in addition to FMLA that are required to be in the employee handbook. And those are things that, that we're going to know state by state, what each state requires to be in the handbook. I mean, just well, failure to put the FMLA notice in the handbook can lead you to an FMLA interference claim, and an FMLA interference claim is going to lead to monetary losses. It could lead to reinstatement of the employee. So you've got an employee and you think, well, we gave them their 12 weeks and they're, they don't want to come back, we're done. And you don't have that FMLA notice in your employee handbook, you've got FMLA interference and you've got to reinstate them. I mean, this is a sort of a worst case scenario, but not having that FMLA policy in there can very well come back to bite you. Some other examples, so Massachusetts has paid family leave that was effective on January 1st, 2021. That's required by law to be in the handbook. The paid family leave, family and medical leave policy is required by law to be in your handbook. You do need to get a signed acknowledgement of that every year. What better opportunity than to update your handbook every year and have your employees sign off on the handbook? Policies included, you just got what you need according to the law. Washington, D.C.'s pregnancy and childbirth leave, the notice is required in both a poster in the workplace. It is the notice is required when an employee tells you that they are pregnant, and it is required to be in the handbook. So that is 3 places that you need to notify your employees of their right to pregnancy and childbirth leave in Washington, D.C. All employees, regardless of whether they are or will ever become pregnant in your estimation. So upon hire, that needs to be communicated. Oregon paid sick leave. So there are certain things in paid sick leave policies, very small things, that need to be spelled out in state and local paid sick leave policies in order for you to be complying with the law. So this is an area where cutting and pasting from someone else's handbook is going to get you in a lot of trouble. Somebody else's handbook may not include the minimum increments in which paid sick leave can be taken. Oregon requires that. If you cut and pasted somebody else's Oregon handbook and they don't have that minimum increments in theirs, you don't have minimum increments in yours now, and some employee can take you to the Bureau of Labor Industry in Oregon and say, my rights were violated. I didn't know the minimum increments in which I was eligible to take paid sick leave. You would be out of compliance in that case. As of January 1st, 2022, there is a new qualifying reason for Oregon paid sick leave. They expanded their permitted reasons for taking PSL. If you weren't updating your handbook every year with the advice of an attorney, you would be out of compliance for not adding that reason to your paid sick leave policy, and you would possibly be denying your employees their rights. So again, updating every year is so important, and having an attorney who knows the laws in all 50 states and is on the lookout for those updates is something that's so critical. Again, Connecticut started paid family leave this year and totally revamped their Connecticut FMLA. It's a radical change to their Connecticut FMLA law, and that is the paid family leave. They require annual written notice of paid family leave as well, like Massachusetts. So that should be a handbook revision and a signed acknowledgement every year. And if you are in Connecticut, your Connecticut FMLA policy needs to be completely ripped out and replaced at this point. And that is something that could happen at any time, any year, in any state. Mistake number 10, what happens to PTO, unused PTO or vacation time at termination? So in some states, accrued but unused PTO or vacation is paid out on termination by default. This means that unless you put something in your handbook specifically saying it does not get paid out on termination, in those states, It does. It doesn't matter why they get terminated. It doesn't matter if they quit. It doesn't matter if they steal from the company and light the building on fire. In those states, if you don't have in your handbook specifically, it does not get paid out on termination, you're paying it out. And that can be if you've got a lot of long-term employees with a lot of high accruals, that's going to impact you financially. So you need to make a decision about what happens to accrued but unused PTO or vacation time, and you need to put that in your handbook. There are some states that say by law it does get paid out at termination regardless of what you decide or not. One of those states, for example, is Colorado. Colorado now requires payout of accrued but unused PTO or vacation time upon separation. You are required, you don't have a choice. Colorado changed that last year, so you need up to the minute state law information. You could have a non-compliant statement in your handbook in Colorado and not even be aware that the rule has changed. So moving on to the OSHA ETS, also known as the vaccine mandate update. So the last that we left it, the Fifth Circuit Court of Appeals had placed a stay on the OSHA ETS. So ETS stands for Emergency Temporary Standard. This is an OSHA rule. It is a rule just like ladders have to have cages on them, or any other rule. You have to have a certain number of bathrooms. Any other standard that OSHA makes, the vaccine mandate is called an ETS because it is an emergency standard that OSHA is saying we are responding to something urgent and we are making this happen right now, skipping the regular rulemaking process. That is why when I say ETS, I am referring to what people commonly think of as the vaccine mandate. Of course, it does not purely mandate vaccines, but it is the ETS is what requires you to implement either a mandatory vaccine or a vaccination or mask and test policy for if your organization has 100 or more employees. So that when I say ETS, that is in fact what I'm talking about. And so kind of the last place where we left it, if you've attended previous webinars, the Fifth Circuit put a stay on the ETS. OSHA said, all right, we're going to fight this, but we're not going to implement or enforce in the meantime. So OSHA did fight, and all of the cases, everybody who was suing to block the ETS, that's religious groups, trade organizations, business groups, 26 states, all of their cases were consolidated and heard by the Sixth Circuit Court of Appeals. The Sixth Circuit Court of Appeals last week did dissolve the Fifth Circuit's stay on the ETS. So there is no longer a stay on the ETS. OSHA is free and clear to proceed at this point. And after the Sixth Circuit Court dissolved the stay, OSHA announced the ETS will go into effect on January 4th of 2022. All of the groups opposing the ETS have applied to the Supreme Court. So what did the Sixth Circuit decide? The majority of the Sixth Circuit Court of Appeals said that OSHA has proved that there is grave danger to employees. They explained that, they said OSHA explained the reasoning for limiting it to larger employers, and they're saying OSHA is required to navigate the rapidly changing landscape in the workplace due to COVID-19. The dissent, so the majority dissolved the stay. The dissent, the Sixth Circuit judge who disagreed, their position was you can get COVID anywhere, so it shouldn't be an OSHA issue. They didn't prove that COVID is a grave danger. They shouldn't have made masking and testing harder on employees than vaccination. So that's the dissent. That's kind of the judge that lost, that was in the minority. But those were that was some reasoning that was thrown out, and that is something that that when everything is being considered all together by the Supreme Court, that the Supreme Court will think about it. They will consider both the majority opinion and the dissenting opinion. So right now, like I said, January 4th is the compliance date. There will be no citations for non-compliance before January 10th. As of January 10th, you should be prepared to comply. No citations for non-compliance with the testing requirements before February 9th if you are making good faith efforts to comply with those testing requirements. So the emergency, there's been an emergency appeal to the Supreme Court. As I said, emergency appeals to the Supreme Court, this is a request to stay the Sixth Circuit's ruling, so a request to put the hold back on the ETS. When there is an emergency appeal to the Supreme Court, that goes to the justice assigned to that circuit. Justice Kavanaugh is assigned to the Sixth Circuit. The appeal goes to him. He can put the request before the full court, or he can decide it on his own. At this point, Justice Kavanaugh has asked the Biden administration to respond to all of the appeals, so from the states, from the business groups, from the trade associations, from the religious group, and he has given the Biden administration a deadline of December 30th at 4 p.m. to submit this response to all of the appeals. The Supreme Court will likely take action in early 2022. They are only deciding whether OSHA can go forward and enforce and implement the ETS. So all of the lawsuits will wind their way through the lower courts. Even if the Supreme Court says OSHA can go ahead and implement and enforce the ETS, it does not mean that the ETS is here forever. Even without the lawsuits, an ETS technically can only last 6 months before OSHA has to either drop it or make it a permanent rule. So we're looking ahead into next year to determine the fate, regardless of the lawsuits. But the Biden administration is prepared to respond, and OSHA currently has the power in their hands to implement and enforce, and they will have that power until and unless the Supreme Court takes it away. And so, like I said, non-compliance citations can be issued starting January 10th. It is unlikely that we will have a Supreme Court decision before January 10th. Don't sit on this. This is, don't roll the dice and hope for another stay on this. Be prepared to go forward and have your OSHA compliant policy and start enforcing your OSHA compliant policy, and start your record keeping, and start collecting proof of vaccination, and start implementing a mask and test plan if you're choosing masking and testing. You need to go through all of that. States with state OSHA plans have 30 days to issue, either adopt the ETS or adopt a more protective standard. So far, only California has adopted a more protective standard. Some states with their own approved state OSHA departments have said that they will not accept the ETS. That's going to put your state OSHA department in jeopardy. Puerto Rico has made their own vaccination mandate for employers with 50 or more employees. So in Puerto Rico, it's not even necessary for their state OSHA to adopt it. And OSHA says that the ETS preempts all state and local laws, but all we have so far is a stay and then a dissolution of the stay. All of these states and other groups filed a lawsuit. We do not have a decision on the merits of that lawsuit. So technically, we do not know whether all state and local laws are preempted. This is a minefield. Again, you want legal counsel to help you navigate this to make sure you are in compliant. I did have some state law updates. We do not have time to get to those state law updates. Certainly you will get the deck, as Daniel said. And if you are concerned about any updates in your state, that is something you can open a ticket about, and we do share those updates in our newsletter and elsewhere. So I
Thank you,
will,
Britt. Oh,
oh, I was just going to say, I'll turn it back over to you.
can you go ahead to the last slide, please?
Yes.
Awesome. Well, thank you so much, everyone, for attending. We hope that everyone has a great New Year and holiday season. If you are a client of ours and have any questions on the material, as Britt mentioned, please open a ticket with us in our Ask an Attorney portal. And then if you are not a client of ours, we do offer our Ask HR service, which includes unlimited on-demand access to our employment attorneys. You'd get legally drafted vaccine policies, a legally drafted employee handbook, and that starts at just $1.99 per employee per month with as low as $99 flat fee. So if you have any questions or you want to learn more about our services, please reach out to us at info@myHRcounsel.com. We'd be happy to get a demo set up for you. And once again, thank you very much for attending. Have a great rest of your day.